Good morning, sir. This is Likita.
Hello, Lekita.
Hello, sir. Aditya here.
Hello, Aditya.
Today, we want to discuss judicial accountability and judicial reforms with you. In the news, there has been a lot of discussion about judicial corruption, especially in the instance where there was a lot of cash found at a Delhi High Court judge's home. And also, the Pooja Khetkar issue, where her protection was extended by the judges, despite their clear evidence of being fraud committed. So, what are your views on this?
I think it's a good opportunity, Likita, to examine the role of judiciary. No serious student of democracy questions the role of judiciary. It must be independent, impartial, strong, efficient, and must be able to ensure that all organs of state adhere to the constitutional norms, including judiciary itself. Now, the case or cases you mentioned, they're a very interesting intersection of many things: integrity, competence, impartiality, constitutional propriety, and democracy itself. So, in that sense, A, you must examine each case and merits individually. B, you must look at the bigger picture and see how to make the constitutional order work. I think any objective assessment today shows that the constitutional order in terms of our justice system has been very deficient. To pinpoint the specific issue, we have something like, I don't remember the exact number, but probably about 16 or 1700 constitutional judges in the country. Every judge of the High Court and every Supreme Court judge is a constitutional court. They constitute the higher judiciary. And the appointment to these courts is very critical because they not only render justice in the normal course, they're not trial court judges merely, they're appellate court judges, but they actually have the power to interpret the Constitution and give orders and write petitions, protect citizens' liberties, and hold the government to account, or even legislature to account by holding a certain law unconstitutional or whatever. So it's a very weighty power, a power not granted by the people, a power granted by the constitutional system within certain limits. It will be useful to understand what the constitution makers wanted. I was just now going through a quote of Dr. B.R. Ambedkar. He said, "I have not anywhere found in any constitution a provision saying that the executive shall obey the legislature or judiciary." And it is to be presumed that those who work the Constitution, those who compose the legislature, and those who compose the executive and the judiciary know their functions, their limitation, and their duties. No constitutional government can function in any country unless any particular constitutional authority remembers the fact that its authority is limited by the Constitution. Now, what happened in India is, since 1990s, because of a mistrust of politicians and political process, anger of politics, middle class, media, we are all indulging on a day-to-day basis in politician bashing. It's a very favorite pastime in Indian public discourse. And of course, politicians are bashing each other every day. They're making it very easy. Because of that, somehow we came to believe that there are non-political solutions to political crisis. And if only you gave authority not to the government elected by us freely and voluntarily, but to a group of civil servants, initially that was the belief. In 1960s and 70s, any problem, any controversy, there used to be debate in the assembly or parliament, and they said, all right, we'll appoint an IAS officer to inquire, and everything is to subside. Once those scales have fallen, once people have realized that civil servants are not a substitute to democratic process, we started believing since 1990s that courts are the answer, judges are the answer. No, those scales are falling too. Now, will we go to generals? Will we go to some armed forces? Or some Superman. This is a very uninformed, immature, and hasty approach to dealing with the political process and governance challenges. And in many ways, what is happening, some of these instances, while they're sad, they're not surprising. Because once we created a framework in which one branch of government is practically unaccountable and self-appointing, two very dangerous things. The politician is accountable because he or she has to go back to people again and again and again. Apart from the parliamentary procedure, the government can be brought down and so on and so forth. But there's also another accountability, ultimate accountability of the voter deciding your fate. I'm not saying it's perfect. Our democracy is not perfect. But accountability is real because 50% of all members of legislature, state or national, we take across the country for the past 70 years, 50%, half the incumbents are not returned to office in the next parliament or assembly. Either they're retiring, they're not given seats by their respective parties, or they're defeated. Even if the same party comes back to power. What we call disaggregate volatility. Even if the same party comes to power, it looks as if the same party has come back, there's stability. But at a disaggregate level, the candidate level, there's a high degree of volatility in India. In America, for instance, when 1994, during Bill Clinton's presidency, Newt Gingrich staged what they called Gingrich Revolution. If I remember, some 37 members of the Congress were unseated in that election. Out of 435, about 8%. They called it a revolution. In India, in every election, 50% of members are unseated. So there is a very high degree of accountability. Even if political process is messed up, it's not for want of accountability, per se. There are many deficiencies. FDR and Lok Sabha have been fighting these abuses of the process or the abuse of authority in this country or the deficiencies of democracy day in and day out. But there is accountability. A civil servant, while excessive protection is given, is still accountable in this country. A civil servant can be sacked, can be reprimanded, can be reduced in rank, or do any number of things by the executive branch of government, by the investigating authorities, by the courts, and so on and so forth. The court, by the 1990s judgments, a series of well-meaning, I'm sure, but ill thought-out, unwise judgments or orders, the courts have taken over, appropriated the power of appointing themselves. Nowhere in constitutional democracy was it ever true that any authority of the state was appointing itself. Every single functionary under the Constitution must be directly or indirectly appointed by and accountable to the people. Either the people appoint you in the name of the parliament or assemblies, etc., or the elected legislatures in turn appoint you, or the elected government and legislature together, they are part of the process of appointing another authority. Now, if tomorrow a district magistrate says, I want to govern the district very well, and the chief minister is not appointing me properly or my successors properly, if I'll decide who my successor is. If a judge says, I don't trust the government to make good appointments, I'll decide who my successor is. It is utterly undemocratic. It is completely violative of the Constitution that we allowed things to come to this pass and that we accepted this so meekly. That is what led to these consequences. The second part is the Parliament has failed woefully. I must say with great humility, but at the same time great firmness. Because the Constitution ultimately gave the power to the Parliament to remove judges who are found wanting in terms of probity in public life or in terms of the discharge of their duties. Not once has Indian Parliament acted to remove a judge. So, in effect, though the power exists on paper, in reality, a judge cannot be removed in India. Every single constitutional court judge, all the 1700 judges. Now, you combine these two things. We can appoint ourselves. Once appointed, you cannot remove. Thank God there's a retirement. If they're appointed for life, as in the United States, with this framework, it would have been an unmitigated disaster for this country. So I think they must be very careful, thorough, dispassionate, non-partisan examination of the issues. On the one hand, we need a competent, independent, effective, impartial judiciary. There's no question about it. On the other hand, the democratic principles and accountability must be restored.
So, then in this case, how do we bring about transparency and accountability in judicial appointments and removal without compromising judicial independence?
We are not alone in the world, Nikita. We are not the only democracy in the world. Every other democracy, a functioning democracy, is guaranteeing independence of judiciary, and yet appointments are made by a process involving the political process. Take the United States. Nobody argues that American Supreme Court is not independent or American federal courts are not independent. Even a man of Donald Trump's power and temperament is being challenged by a simple federal court, not even a circuit court of appeal or a Supreme Court. And day in and day out, we are seeing the news every day. Nobody doubts that. How are they appointed?
By the executive.
The president nominates and the Senate confirms. So who is the president? The elected chief executive of the country. Who are the senators? The elected representatives of the people of the country. That did not diminish the independence. Go to Britain. It's not even that process. The Prime Minister and the Minister in charge of the Justice, the Attorney General or Home Secretary.
The Lord or Lady Chancellor.
They appoint. Go to Germany, the Justice Secretary or Justice Minister. So there is no country where appointment is made by any other process other than by the executive legislative branch of government with inputs from the experts. There's a whole list of countries where appointments of higher judiciary are there. There's not one country where judiciary appoints itself. And they all have independence of judiciary. So to argue that judicial independence will be ensured only when judges appoint themselves is an absurd and very specious argument.
So, allow me to play the devil's advocate here and bring in emergency to the context. During the emergency, we saw the norm was seniority of judges was preferred, and twice in 73 and 77 that was overtaken, right? The most senior judge was not appointed. And the term that came up across was court packing the court with judges that favor the executive. Do you think the 1990s of colegium system, as you said, which is the judges appointing themselves, an outcome of India's emergency? So, in that case, when India has suffered that, where executive appoints judges to favor them, how do you balance that?
First of all, if you take the chronology, emergency ended in 1977. The judgments came in mid-1990s, 16 years later. And we no longer had an Indira Gandhi or anything close to Indira Gandhi. Yes. Actually, by 1990s, mid-90s, by the time of these judgments, governments at the national level are weak,
yes,
coalition, unstable. So to somehow see a link between emergency excesses and therefore the desire to remove those excesses, I think it's stretching it too far. In fact, now that you raised the issue of emergency, let me go back to emergency, post-emergency developments. There was that infamous case, Shukla versus ADM Jabalpur, what is popularly known as habeas corpus case. I followed that case very, very closely, the arguments in the court as a youngster. Attorney General Narayan Day, he was the one who actually argued before the Supreme Court. H.R. Gokhale, if I'm right, was the law minister at the time. Narayan Day argued that once fundamental rights are suspended under the Constitution during emergency, the citizen has no recourse to courts if the rights are violated. When the judges prompted him, asked him to give an illustration, he said, if a constable in uniform kills a citizen, as long as he is a uniformed constable, there is no judicial recourse. to the eternal regret and shame of the Supreme Court of India, I'm using the word shame advisedly, the court upheld that contention. It's not able to live down that terrible judgment even today. The one judge who opposed that, H.R. Khanna, very intrepid judge, he was denied the Chief Justiceship later during that time. And I had the privilege of working with him and the parliamentary panel in the National Commission to Review working as a constitution and parliamentary reforms. But what happened post-emergency? Morarji Desai was the Prime Minister. Some of the ministers, quite rightly, understandably, in fact I was agitated too, like many others, in particular George Fernandez and Mr. Charan Singh, they argued that Justice Chandrachud, who was the senior most judge, due to becoming Chief Justice in the normal course by Indian practice, though it's not God-given rule that the senior most man because of age automatically becomes the Chief Justice. But in India somehow we believe in gerontocracy, in bureaucracy, in judiciary. It's not competence. Justice Roberts was probably the youngest judge when he was appointed as Chief Justice of the United States. If I'm not mistaken, he was an intern when some of his colleagues were judges of the Supreme Court. He interned with the former Chief Justice Rehnquist, I think, if I remember. But there was absolutely no criticism or objection, no eyebrows raised when a young person was made Chief Justice of the United States. Nowhere in the Constitution does it say senior most man must be there. But anyway, we practice that. Probably that is better in a country where we don't trust each other. So Chandrachud should be appointed or not was the issue. Quite rightly, Mr. Fernandez and Mr. Charan Singh argued the people who ultimately did not protect the freedoms of people in a moment of extreme, grave national peril, how can you make them Chief Justice? As a young person, I sided with that argument. Morarji Desai, the veteran Gandhian, he said, look, if we now bypass Chandrachud, even for valid reasons, we would have upheld the argument of Mrs. Indira Gandhi. Therefore, let us not do that. It was an extraordinary decision. It takes great statesmanship and foresight to make that kind of a call. Justice Chandrachud publicly apologized. He said the conditions then were different. An apology of sorts he gave. I remember vividly. In fact, in my IAS examination, I wrote all about this. I don't remember an answer to each question. So that issue was corrected by political process, not by judges. The misdeeds of emergency or curtailment of liberties or judicial excesses or judicial appeasement or whatever was undone not by the judicial process but by democratic process, political process. And therefore for the judges to argue that will be very churlish. I don't think there's a ground for that. And the judge who gave the judgment, the judge's case, was a man of unimpeachable integrity. Justice J.S. Varma, whom I came to know very well later. Justice Varma, along with Justice Venkatachalaya, the Chief Justice at that time, and Justice Krishna Iyer, one of our most legendary jurists of India after independence. They three together, they came together to recommend National Judicial Commission. On the basis of a paper, we presented a detailed paper about outlining the appointment procedures all over the world, best practices, Indian conditions, and so on and so forth, appealed to them to come together and give a guidance to the country. So the very judge who wrote that, a man of unimpeachable integrity, at the time, because they were worried, it's a fact that in democratic practice in this country, from appointing or nominating candidates to elective office, choosing civil servants to key positions, to on occasion appointing judges, nobody is arguing that everything was perfect. Democracy by its very nature is imperfect. And in our democracy, there are many flaws. We've been fighting those flaws every single day, right? FDR exists to fight those flaws and to help correct those things as a people's movement. So it's not our argument that democracy is perfect. It's our argument that the imperfections of democracy cannot be separated by the tyranny of the unelected in the name of judicial independence. And it is a well-meaning intervention of the judges at that time that led to a situation. And you have seen, if you take the appointments, Justice Ruma Paul, she became Supreme Court judge in 2000. In 1990, she became High Court judge. From 2003 to 2006, she was a member of the colegium. She made very scathing remarks about the collegium. How utterly obscure, non-transparent, arbitrary the process is, or how it's scratching my back. You scratch my back, I scratch yours. It's a negotiation and deal-making kind of a thing. Everybody who has understanding of the judiciary in the country, every senior member of the bar knows that. There's a conspiracy of silence for a variety of reasons. You take the totality of judicial appointments. There are outstanding judges now, as there were outstanding judges earlier. But I dare say, on balance, you cannot argue that the average quality of judges in the High Courts and Supreme Court of India has in any way improved over the quality of judges before 1990s. Some people may actually argue that there's a tremendous deterioration. So it's wrong in principle and it's bad in practice. The results are bad. So what are you talking about? What did Dr. Ambedkar say? He said, nowhere in the Constitution does it say one organ must obey another organ. The executive cannot be told what to do by the judiciary or by the legislature. Each organ has a place and they must function within the constraints of the Constitution. Now, our Supreme Court is now trying to say, has been trying to say for quite some time, that we have no constraints. You all have constraints, but I have no constraints. I'll do whatever damn well I please, and that's the end of the story. Indian political system very graciously and wisely embraced the notion of basic features of the Constitution, the doctrine. Very few countries have that. I too support that. There are many purists who say, how can the court decide? The Constitution decides itself and the political process. But I believe balance of convenience in India lies in having some kind of an understanding of what are the basic features. But you cannot be elastic about basic features. Universal franchise, fundamental rights, due process of law, federalism, rule of law. A few things which are self-evident, they can be basic features. But you cannot bring and say, if a judge is transferred basic feature, if my little finger is hurt a little bit, basic features. You cannot be. You're making a mockery of it. And eventually you're undermining yourself. You're not only hurting the constitutional process and democracy and the country, you're hurting yourself. That's what happened today. Have you ever heard of the kind of outcry and anger that's generated now in the country? Just because you took advantage of the general mistrust of politicians in a country where there are serious challenges in a democracy, because we are still learning. A fledgling democracy, where a strange democracy where for the only country where on day one everybody got universal franchise right to vote, without literacy, without any kind of wealth, and without experience. And male, female, religion, caste, no bar. It's a remarkable tribute to our founding fathers. That we are actually making that work is a remarkable tribute to our society with all imperfections. But obviously, mistakes are bound to occur. We have to learn. It takes time. Now, you cannot take advantage of that and then say that I am superior, because A, it's not constitutional, B, you failed. You have completely failed. So I think there has to be very honest appraisal. I completely disagree with the notion that judges are here to satirize the distortions of either emergency or democracy. It's not their job.
So then are you making a case for a Judicial Appointments Commission?
Absolutely.
Or an All India Judicial Service?
Both. In fact, the FDR and Lok Satta were in the forefront of that effort. Now for the past 15, 20 years. We started this process way back in 2004, 2005, 20 years. Umpteen number of times we've had opportunities to discuss with the highest functionaries in the country, in power and in opposition. The Prime Minister, the National Advisory Council Chairperson, the opposition leader, the ministers of law in various governments and various the most important political functionaries of this country, repeatedly, formally and informally. On that basis, we appealed to 3 jurists, Justice J.S. Varma, who himself gave the judgment, because these men are so honest, so principled, that they were willing to recognize that their own well-meaning judgments actually led to consequences that are not really favorable to the country. Otherwise, why will Justice J.S. Varma, who actually gave the judgment about the judicial appointment in the collegium, and Justice Venkatachalaya, who was the Chief Justice at that time, why will they be part of that? Because they realized they are men of unimpeachable integrity. And Justice Krishna Iyer. Now, you may or may not agree with them on all judicial pronouncements, because after all, there is always room for different kinds of interpretation. But nobody in the country can question the integrity and the commitment to judicial independence and democratic values of these 3 great jurists of India. So they came together at our urging, and we prepared a detailed background paper, because ultimately you can't decide in thin air. It has to be based on evidence, logic, best practices all over the world, and you have to innovate, adapt it to your unique conditions, because no 2 conditions are identical. And you must make it work. So they deliberated a great deal and then came up with this. And at each stage, we kept the political parties and the key functionaries of India, in power and opposition, informed. I don't believe in great publicity and all that. But quietly, transparently, and with full knowledge of the key functionaries, and all this kept in the public domain. The discussion paper was and is in public domain. The correspondence is in the public domain. And finally, when I look at the records, I don't remember, I did not recall the dates earlier. On 27th of April 2011, I personally requested the Prime Minister, when I called on him, to meet these 2. Justice Krishna Iyer was not mobile. These 2 Chief Justices, former Chief Justices, were part of this group, and we met and gave details. And we wrote to every single party with all the details of what their recommendations are. And the 2 key recommendations are National Judicial Commission and Indian Judicial Service. The National Judicial Commission that they recommended was a 5-member commission. They wanted the Vice President to chair. They wanted the executive branch to be represented by the Prime Minister or his nominee, a minister. And they wanted Chief Justice and 2 senior-most judges, therefore the 5-member. And they recommended that as a principle, there must be unanimity in selection. Because if even one person has genuinely valid objections, not, I don't like your face, I don't like his caste, but here are the grounds, and therefore maybe is not suitable, then the commission must say that person is out. Unless everybody agrees that the person has impeccable credentials, we must not appoint that person. That was their view. I don't know if it works in real life. I hope it works, but that's the way it should work. But sometimes, it may not also. But given the fact that Vice President, who is expected to be above the fray in general, though they are party functionaries in earlier life, and the 3 justices are there, hopefully that would have happened. But the idea is that the idea of All India Judicial Service is about how to induct quality into judiciary. Legal practice, law practice has become very remunerative in India. Competent lawyers make tons of money honestly. They deserve it. After all, it's a profession. Anybody can compete, you make money. Whereas judiciary does not pay. Any government employment, even if you are Prime Minister of India or Cabinet Secretary of the country, you cannot be paid that way. Nowhere in the world. So how to attract the best? Somehow we are not able to attract the best into judiciary. There are some great jurists, some brilliant jurists, but it's becoming increasingly difficult to attract fine people into judiciary. Unless you attract fine people into judiciary at a district judge level, at a trial court level, which becomes eventually recruiting ground for the higher courts, the quality suffers. So for that reason, for long, we have been arguing that should be an Indian Judicial Service. And the Constitution made a provision. It's the only All India service which was named They said the parliament, particularly by a resolution of the upper house, here, as you know, the Council of States, Rajya Sabha has primacy, can create an all India service. In particular, they mentioned Indian Judicial Service. The constitution makers understood the need for that. And these two things were very strongly recommended by this team. In fact, Justice Krishna Iyer went even further. Justice Krishna Iyer argued, in fact, his letter to this, appending his comments on the report of this team, he said about impeachment, even removal. The process of removal of judges of high courts through the impeachment under Article 124(4) has proved to be both cumbersome and unsatisfactory. Therefore, if there is political consensus, it may be desirable to amend the process of removal of judges. In such a case, based on the findings of the Oversight Committee envisaged under the Judicial Standards and Accountability Bill, the NJAC will be empowered to recommend removal of a judge on the ground of proved misbehavior or incapacity. He went that far. But I urged him, while I completely agreed with his stand, for reasons of unanimity in this group and for reasons of the need to carry broadly the higher judiciary in the legal community, let's not go that far. But as I mentioned before, impeachment process has failed in India. Nobody can argue that every single judge had a spotless reputation in the country. I mean, let me be blunt. Nobody can argue that. And people who have some understanding of litigation in the country, they tell you any number of sorry tales of what's happening in some elements of our justice system. There are exceptional judges. The men and women have great integrity and competence, no question about it. But there are also several black sheep. But we could not discipline them in the country. So I fully sympathize with the stand that Justice Krishna Iyer was taking, but one thing at a time. A third thing that they've argued is what Justice Krishna Iyer was mentioning. In fact, Justice J.S. Varma himself, as Chief Justice, recommended, first of all, a judicial code of conduct, and then on the basis of which a bill was drafted. And in the NAC and another fora, I was very much involved in discussing, looking at that. Judicial Standards and Accountability Bill. Nobody is talking about that. You see, impeachment, removal, appointments are very critical. But in between, supposing there are complaints against a constitutional judge, nobody knows what to do. For instance, right now there's a complaint. Nobody knows what to do. Chief Justice says something, Chief Justice of the High Court says something else, and what happens next to you, nobody knows. Then you transfer to another place, then that bar is now on rampage and says, no, look, how we are not a dustbin. You can't simply dump all the unwanted judges here, and they have a legitimate point there. So what happens next? Whereas the Judicial Standards and Accountability Bill provides for that mechanism. If there are complaints, there is a quiet, independent judicial process mandated by law to deal with these. And then once they give a report, if it warrants further action by the parliament in the form of impeachment or something else, they present it to the president, parliament, whatever. So all these are absolutely necessary. Any system, it cannot function without the functionaries being accountable, being transparent at every stage, appointment, removal, inquiry, and conduct in general.
I think the Indian judiciary is so reluctant to accept reforms, especially when it comes to appointments.
No, it's not fair to single out judiciary. No organ which enjoys privileges wants to reform. If I take the IAS, I was a member of the Indian Judiciary Service. I enjoyed being in that service. I learnt a great deal. I had the opportunity to do some things. And I received, I believe, more appreciation and reward in terms of public affection than I deserved. So I have no quarrel. But my own tribe, there is a desperate need for reform. While the recruitment, UPSC is doing an outstanding job. Recruitment is as good as it can be. I'm sure there can be some improvements. There are some areas. We don't want to go into details now. But on the whole, nobody can question the recruitment process. But what's happening after recruitment? We are getting not the best out of them. Only a few are really able to measure up to the standards required for this great country and its challenges. if you judge them by integrity, by competence, and by passion for public good. Demonstrated in action, not in words. Why? Because the incentives are misaligned. There is no specialization. There's a lifelong tenure, no matter what you do, what you don't do. And there's an automatic promotion by seniority. There's no need for competition with anybody else. Whereas if we really care for ourselves as a country, we deserve the best in a field to take care of that field: education, health, national defense, or finance, or infrastructure, or industrialization, or anything. We deserve the best. A country of 1.5 billion people, a country of 18% of humanity, deserves the best. Not somebody who somehow joined government on a certain date, or his date of birth is a so-and-so date. That's not the basis on which, or somebody who passed an examination on one day, some 25 or 30 years ago. That's not the basis on which you really govern the country. Now, is the civil service ready for this? I am posing this challenge. So it's not about judiciary. It's not about fight against judiciary. Every organ has to question itself. And if they don't, we must question them. Because remember, war is too important to be left to generals. Justice is too important to be left to judges alone. Administration is too important to be left to administrators alone. Politics is too important to be left to politicians alone, at least in terms of discussion. So nobody should think it's their private prerogative. They are not a Gymkhana club. As I think Mr. Arun Jaitley famously said in one of his remarks in relation to this. They are not an elite private club. They are a public authority, accountable to people, transparent. They must be. And they must be humble. And they must be introspective and questioning. It applies to everybody. But the reason why they don't want to change any group is, once we are entrenched in a system, we become permanent priesthood. The politicians are reviled in the country. And I am one of those who strongly argued against some of the misdeeds of politicians. In fact, we are the ones who brought out the list of criminals contesting in elections for the first time in India's history. That led to litigation by ADR and others, now mandated disclosure. But whatever be the failings of politicians, they go back to the people. The ordinary little people of India, as Churchill said, they, by putting the little mark or pressing the button, they are deciding the fate from Narendra Modi to Rahul Gandhi. It is not their private wish, or it is not their pedigree. It is the little people. That's what democracy is. Whereas the other branches which are entrenched, not democratically accountable through the vote, they think that they are somehow superior beings, and there is a contempt for the political process. The kind of language used even in films sometimes. The other day, a third-rate film came where some idiot officer, the dialogue, whoever wrote the dialogue, that person doesn't understand elements of democracy. It's a tragedy that in the name of freedom of speech, all this garbage is spreading in the country. He tells an elected politician, I will be here for 35 years, you'll go after 5 years, who the hell are you, kind of thing. What kind of democracy is this? If you don't respect the legitimacy of the people's will, people's consent, that is the basis of a democratic governance.
So, coming back to the colegium and the NJAC, some nuance I want to bring into the discussion. So, the president can, as of this moment, if the judiciary recommends, can sit at the names and not approve them, and the appointment is stalled for the moment. We have had multiple examples. The one that caught media attention was of Saurav Kripal in Delhi High Court, and the appointment is still pending. There are multiple other judges where the executive has not given reasons as to why they are stalling their appointment, but the appointment is still pending. Do you think that this way, if the executive can stop certain appointments, is one way that the executive can hold the judiciary accountable?
These are sad ways, is it not?
True, absolutely.
The court giving whatever names they want, my chacha, bhatija, you scratch my back, I scratch yours. We have deals. And the executive, when they are sufficiently angry, saying, all right, ultimately the president has to sign.
Yes.
Until Supreme Court says president need not sign, they may say that also. Why not? And the president shall do whatever we say. And therefore we'll stall it. So it's a very unseemly thing. It's a tit-for-tat kind of a thing. So you cannot take anything in isolation.
True.
You cannot say government is doing something wrong by not approving these appointments, these recommendations, without looking at how recommendations are made.
That was my next question. So, sir, when we talk about collegium, this has been widely regarded as a system which is not just opaque at this point, it's just a wall. You cannot see what's the reason of
And
this election.
unconstitutional. Where in the Constitution does it say there is a collegium? Where in the Constitution does it say there is a primacy of the judiciary?
True.
The Constitution says the President shall appoint in consultation with the Chief Justice. Period. Where do you say primacy? And how some people, it's amazing when I hear arguments from alleged lawyers that if any member of the executive branch of government is involved in this, it erodes independence of the judiciary. What is your understanding of democracy and constitution? Pray tell me. You want democracy independent of the people of India, not we the people? And the people elected by the people of India? It's a strange argument that we're actually arguing this seriously in our mainstream media is to me shocking, beyond belief. A third grade child, a child in third grade, an 8-year-old child, understanding first civics lessons, tries to understand what is democracy. Now that you have to tell senior judges of courts, people who allegedly are jurists, about the elements of democracy and democratic legitimacy and where power actually stems from, to me is shocking. We've gone that far because that means our elites have not really imbibed democratic principles. We went along with that. And we have contempt for democratic process. There is much that is wrong with our democracy. I'm not arguing that our democracy is wonderful. But two things I very humbly appeal to people. Let's not be polemical, let's not be argumentative. Indians are very loud and argumentative. Despite everything that is wrong with our democratic process and lack of experience, our leaders, from freedom struggle to constitution making to institution building to governance until today, have done a remarkable job in an extremely complicated situation. Whether it's reservations, in a very complex situation, an impressive consensus for affirmative action. Whether it is welfare, whether it is federalism which was hardly there in the first few decades of the Constitution. The union government had complete sway. Today, states are coming to their own. Whether managing the linguistic diversity of the country or ensuring continuity of government and regular elections, periodic elections, timely elections, and peaceful transfer of power. All this while ensuring at least a moderate level of progress, while we did not grow as much as we should, we did not decline as a country. Given our initial conditions and the complexity of our society, it's remarkable. And some of the social legislation, India is a master. Show me one significant social legislation about social reform, whether women's rights or caste, untouchability, or some other thing, where the political consensus is not available in India. Take medical termination of pregnancy. A country like the United States is fighting like cats and dogs every day whether women should have a right over their bodies or not. In 1971, at the height of India's authoritarianism actually, unanimously we enacted the Medical Termination of Pregnancy Act, and not one voice of protest from any obscurantist or fundamentalist group, from any side, then or now, is ever evidenced. Our political party success, remarkable restraint. So, while we have a right to protest what is wrong in politics, criticize, ask for change and improvement, and all of us are doing it, and I think FDR is doing it every single day. For heaven's sake, count your blessings. Our leadership, with all imperfections, has done a remarkable job. There are many imperfections. Corruption, I have talked more about corruption than most people in this country. The amount of money spent in elections, probably I mentioned thousands of times, particularly in the southern states, etc., minus Kerala. So it's not to argue that our politics is blameless. No, it is to have perspective. Second, such flaws as there are, they can be corrected by people's consent and will and political consensus, not by an external authority taking over. And it hasn't worked. Not only is it plainly wrong and unconstitutional, it simply hasn't worked. It made things worse. So let not the bureaucracy or the judiciary think that they are high and mighty. They know what is best. If only politicians are brushed aside, we give the people this silly thing called the vote, but we ignore the vote. We somehow govern the country. It will end up in an absolute and unmitigated disaster.
I have the copy of the Judicial Standards and Accountability Bill here. When we talk about, because we've mentioned a lot of different things, and to just make it clear for everybody, we're talking about three things. We're talking about appointment, we're talking about removal, and we're talking about accountability, right? Do you, sir, think that, of course, the failure of removal of judges is a parliamentary failure to not impeach any judge?
Definitely. Definitely. That means the governmental failure too. For instance, Justice Ramaswamy case. I'm not going to the merits and demerits of individual case, but that was the only case,
Yes.
if I recall. Later on, I think there was another case which went for impeachment. I think the judge resigned quietly. Recent years, I forget the details. But
Justice
Ramaswamy,
Soumitra Sen, if I'm not wrong. Justice Soumitra Sen,
I think so.
if I'm not.
So whereas Ramaswamy case was played out on a much bigger national theatre. The then Prime Minister, I'm sure for good reasons, I'm not now questioning the details, decided that that impeachment should fail. In that particular contest, because that judge was a former Chief Justice of Punjab Haryana High Court, and in the context of national security, that judge had to make some decisions which are in the interest of Constitution of India and national integrity. Therefore, the political system took a decision. So I'm not going into that. But they set a trend. And they decided not to allow the impeachment to go further by defeating it on technical grounds that there is no quorum. Clear-cut cases of corruption, they were not investigated, the people were not removed. And in a country with endemic corruption, it's terrible. So the point that, take Right to Information Act. Aruna Roy and many of us and I were instrumental in drafting it. The government and the opposition had the political will, but we did the technical job. We made sure that every authority constitutionally mandated in India is part of the Right to Information framework. We didn't want to explicitly say courts are included or not. An authority created under the Constitution is, but courts are not outside the Constitution, right? Do you know, Aditya? One High Court actually argued before the Information Commission of India at that time that they were not created by the Constitution of India because they predated the Constitution during British India Presidency Court, and the initial appointment was by a charter of the Queen. That laughable argument actually was made by the High Court formally before the Information Commission, saying that they are not within the purview of the Information Commission or Information Architecture. This actually happened. It shows, earlier you asked a question, why do they resist reform or accountability? It shows that Indian elites, including those in the governing system, except the people elected by the voters, the much reviled political class, the rest of them believe that democracy is not a serious issue. We have to go through the motions, but we ignore democracy. It's not right. And it's not feasible. And it's downright destructive and dangerous.
So, removal if mentioned, I just want to talk about, in the model that we think of the National Judicial Appointment Committee, what sort of transparency are we looking at, sir? Because as of now, we have no grounds of merit on which judges are being appointed. So, will it be publicly available? Will it be transparent?
I would actually be happy if it's publicly available. At least the record of the judges. And if there are any complaints made,
Yes.
I think people have a right to know. Beyond that, American Congress has a mechanism, very public hearings. In India, probably, we're all very conservative. We probably don't want it. My own, I don't have a definitive view, but I think the credentials should be public. The people under consideration should be public. The complaints, if any, and the grounds on which the complaints are made should be public. But the deliberations and final decision, let it be, as long as it is by a sufficiently diverse group of people representing all the interests, legislature, executive, and judiciary. And they are appointed in a manner that is befitting their stature and ensuring their impartiality and integrity. I don't think you and I want to know on a daily basis. That is my view. But I'm sure there could be other views.
Should the criteria be public? On what grounds?
Absolutely. Absolutely. You cannot simply make an appointment without understanding why you are making the appointment. Absolutely.
So, in other major countries of the world, there has been executive primacy in judicial appointments. What do you think in India? What kind of mix should there be?
I think something like the National Judicial Commission, recommended by the jurists themselves, some variant of or the same as the National Judicial Appointments Commission, is perfect all right. Let's not go into micromanagement. Ultimately, it's the parliamentary thing. There has to be a grand bargain, a negotiation between parties, and you have to even sit with the judiciary informally. Ultimately, the authority rests with the parliament. See, in India, we're getting confused. Lawmaking is the supreme authority of the parliament and responsibility. They may consult anybody they wish. They don't have to take anybody's view into account. It's up to them. So somehow in India, we come to believe that people outside legislature have a right of vetoing legislation. It's absolutely wrong. I'll give you an example. When the 73rd, 74th amendments were being enacted, I understand that the government unwisely asked the election commission if they would like to conduct the elections of the local governments. As if election commission will decide what they should do under the constitution and the law. Mr. Seshan, the chief election commissioner, a great friend of mine until the end of his life. I was one of the few friends he had because Mr. Seshan had the propensity to be a little acerbic, we all know. He said, no, I'm not conduct the elections. I'm not here to conduct Rotary Club and Lions Club elections. It is inimitable style. And the government immediately resigned and they created a state election commission. A wholly unnecessary thing. A wholly unnecessary thing. Because there is one structure of government, union, state and local. It's all part of the democratic process with the clearly divided powers. And the 7th schedule for the union and the state, 11th and 12th schedule for the local governments, rural and urban. And you cannot ask a functionary of the constitution or the law to decide whether or not she or he will discharge those functions. So similarly, courts also, I believe in the interest of the harmony, in the interest of the long-term future of the country, there should be a quiet consultation. But it shall be the prerogative of the parliament to decide. And it shall be our duty to go by the law made by the parliament.
So, one small question. When we talk about the NJAC, 46% of cases in the courts today are filed by the state. State is a litigant there. What stops or what safety mechanisms can we envision to make sure that there is not a quid pro quo relationship between the state appointment and the judges?
Until 1990s, we had judges. We had the state as a litigant. Was there any serious complaint that because judges are appointed by the state and state as a litigant, judges are being partisan? So it's a very facetious argument. See, in India we use the word state. In the rest of the world we say the people.
Yes.
Supposing you said the people, then what happens? The state is not Narendra Modi or Revanth Reddy. The state is not acting on their personal behalf. The state is the custodian of the people's collective interests. We are forgetting that. Because of our animosity to political process. And therefore the state, we think the state is not the people. The people are different. No. Much of the rest of the world, state is the people. In the US, if I'm not mistaken, criminal case, they say people versus so and so. So this argument, these are all very, very weak arguments. Either without any deep understanding of what it's all about, or desperately clutching at straws to find some argument to favor status quo.
So, not favoring status quo, I want to understand that can there be a way if a judge, if it is established that there is a quid pro quo relationship, should we have a caveat saying if there is something, there could be a higher degree of, there could be quick impeachment, something of that
That's
sort?
what impeachment is about. Any kind of a major misdemeanor, any kind of failure of constitutional duties is what impeachment is about. And even judicial standards accountability.
Yes,
That's what,
yes.
Even short of impeachment, let there be investigation. See, the conduct as judges must be completely transparent. And luckily, in case of judiciary, unlike other branches of government, whatever they do, whatever they say, everything is documented and recorded. You cannot fault the judicial system for that. Not because the judges today made it happen, because that's been the tradition and custom in India and for all over the world. So a judge cannot simply say, like Solomon, I like your face, Aditya, therefore I grant you. Maybe that's what they're doing in some cases, but at least they can't say that. They have deduced reasons. Therefore, there is a system available. Let's verify.
Sir, in England and Wales, there's a judicial appointments ombudsman that monitors the way appointments are made. Is a body like that feasible for India?
No, there are so many models, Likita. We can look at all this. But I am a great believer in minimal dislocation, maximal impact. Maximal amendments of the Constitution, maximal legal framework with minimal outcomes is not a good idea. Already we have the longest Constitution in the world, remember. With good reason they have written, because many people argue it's unnecessarily long, but it's not entirely a correct argument, except in respect to 73rd, 74th Amendments, which we later on added. Verbose thing, which is meaningless really. The provisions of the 1935 Act, Government of India Act, many of them are brought in for the functioning of the government so that there's no dislocation. So they really are not the soul of the Constitution. They're more like laws, but they embedded in the Constitution. But excessively overwriting is not also very desirable. So minimalist approach with maximal outcome, but don't kill the soul.
So probably the last question. I've just on a lighter note, when you talk about reforms and being hesitant to reforms, do you think that because reforms require a lot of intellectual crunching and different models, comparing them, combining them, is why people are hesitant, or like people in power are hesitant?
It's partly that too. It's not one, it's many. That certainly is one of them. I say this very sadly, we have lost the capacity to even draft good legislation, even draft a good constitutional amendment. I'll give you an example with which I have personal experience. The 97th Amendment of the Constitution, guaranteeing cooperative autonomy. Basically, we have argued from FDR Lok Satta that cooperatives must be on par with, they're actually people's organizations like any other society. 19(1)(c), the fundamental right, gives the people the fundamental right to constitute and run a union or a society or a union, trade union. Cooperative is actually a society. Because of judicial mispronouncements, because of executive excesses, cooperative autonomy was eroded. Dr. Varghese Kurian, among others, many other cooperatives in the country were fighting. I was inspired by Varghese Kurian. He was one of my mentors. I was also Apex Cooperative Bank's MD in the Andhra Pradesh state earlier. Because of that experience and Kurian's influence, we advocated including cooperatives in the 19(1)(c), so that the protection available to societies, the people's organizations, under the Constitution is available to cooperatives. It actually should be there earlier also, but to make it explicit. Now, unnecessarily, the government wrote a whole chapter in the Constitution. I pleaded with them, this is enough, no more, no less. Anyway, it's a political judgment. I'm not questioning their prerogative. Look at that schedule, I think it's the 13th schedule, if I'm not mistaken. Look at that schedule. Or not the schedule, I think chapter, the same chapter as the local governments. It's added as C or something. Relating to under 243 extension, I think. They put it somewhere, but a long chapter. Two things I'll give you examples. How the elegance of the Constitution, understanding of constitutionalism, they simply are disappearing increasingly in our legislation. For the first time in the history of our republic, the expression central government finds place in the Constitution in that particular amendment. While we habitually use the expression central government in our government orders, in our debates and discussions, sometimes even in legislations, sadly, I'm completely opposed to that. There's a union government, there's no central government. For the first time, Constitution said, under the 97th Amendment, central government. I'm not saying it's a very substantive thing, but it speaks of our understanding of the constitutional framework and lack of elegance. The second thing, the the people who framed the law or the particular amendment, they wanted to say that in respect of credit institutions, banks, there must be you can't have autonomy in the name of a cooperative to a bank, right? Because the financial architecture of India, financial stability of India, this must be governed by some other legislation, Banking Regulation Act, for instance. Now, what they intended to say was quite right, that in case of credit institutions, it must be governed by a regulatory law made by Parliament. Instead, they said it must be governed by Banking Regulation Act, a particular law. Now, every school student of Constitution understands Constitution is the highest law. The law made by Parliament or legislature is subordinate to the Constitution. The rules framed by the bureaucracy but approved by the legislature implicitly or explicitly are subordinate to the law, and the orders made by the executive are subordinate to the rule, right?
Correct.
Here is the constitutional amendment where it says Constitution is subject to so-and-so law. Now, I'm not saying they're very substantive issues, but they are very good illustration of how muddled our thinking is and our capacity is. But that's one of the things. The real problem is much bigger. This is only a drafting issue. Real problem is our understanding of democracy and the grand scheme of things, the constitutionalism, the primacy of the people of India. That's what the Constitution is. We the people. We are forgetting judicial primacy. There's no judicial primacy. We the people. The primacy of the people of India. Now, any organ which believes that the people no longer matter or their mandate does not matter, we are in serious trouble. I'm not arguing for a moment that there's no need for independent institutions. These are two different things. We require a central bank. Though central bank doesn't have the same autonomy, it's not even a constitutional organ. We require a CAG. We require a finance commission. We have a public service commission. We need or not is questionable, but anyway, it's there and they're doing a great job. UPSC. I don't know if it's the state commissions. We require the courts. We require an election commission. But what I'm arguing is they cannot be Swayambhus. They are not gods. They cannot exercise divine powers. They cannot claim divine powers. They are all within the framework of the Constitution, and they are all accountable to people of India, we the people, directly or indirectly. And the way that link works is the people, their vote, elected legislatures, elected governments, and then somehow find a direct-indirect link. And the moment you say you snap the link, you're no longer part of the Constitution.
Thank you, sir. That's
Thank you
it
so
for
much.
today.